Hello, everyone. This is Gilbert Gillard. I'm talking to you here from Private Corporate Counsel, downtown Orlando. You can call us at 877-647-7887. Again, that number is 877-647-7887. This is Tufts on Tax, where all your tax questions and wondering about taxes and anything about forms related to taxes are answered right here with Mr. T. Scott Tufts. T. Scott, how are you today?
Hey, good to be with you.
Good to be with you too. And today we are back with another form, and this time it's Form 211 for the IRS Whistleblowers. So what's the latest developments about this form?
Yeah, so, we show our audience, we have this Form 211, and the process of whistleblowing with the IRS is you can make an application for an award. Many of our audience may not be aware that you can do this at the state level as well in a number of states for state taxes, but this is at the federal level for federal taxes. And the process of whistleblowing is not something that you should do lightly. It's something that needs to be thought through and carefully, because there's a lot of information requested on tax forms. We talked a lot about that tax forms have a lot of information on them. You need to fill them in carefully and whatnot. But
I believe we talked about the whistleblowers Form 211 previously.
Absolutely.
In previous episodes.
So what's going on now in the law has been that you have the process of applying for an award, but then there's a whistleblower office at the IRS that could deny your reward. Let's say you make an application for an award, you believe taxes have been collected by the IRS, the Department of Treasury. You make an application, they deny it. And you say, okay, they've denied it. Let's say they give you a stated reason and you wish to contest that. That is done before the United States Tax Court. Okay. And so it's a process that occurs at that point. The tax court's been reviewing whistleblower claims since 2006. Actually, I think there were, by the time they got going, but basically the law is in place since 2006. And the tax court has struggled with how, now for those of you who don't know, the tax court is a court of limited jurisdiction, which means that it only hears cases that it's prescribed to hear based on tax matters. It's kind of an informal court as far as discovery, but then, and not a court where you have a jury trial. It's bench law, as it were. But that's where you contest tax matters. And one of those matters you can contest before the United States Tax Court on an appeal of a decision that you do not agree with is whistleblower awards. Now, the question that has come up, Gilbert, in recent years has been that the court does not have jurisdiction unless they actually have collected taxes and based on your information, and let's say issue an award that says, okay, here's $10 and you believe you're entitled to $100. Now, those are much smaller numbers that we're talking about, but I'm using that as an example. The court has now been asked, because of a court decision named Lee, L-I, that the thought is that they only can decide an issue that and have jurisdiction over a situation that I described. They issue an award, but it's not what you believe you're entitled to. So there's a difference between amount. You follow me?
But they base that award based on what?
So so when you file your application, they research whether or not it's a viable claim. Okay. But remember, what you're applying for an award. But that's a great question. When you're applying for an award, you're giving them information on a tax violation. Well, if they go off and investigate the matter and then go get taxes, right? And all appeals are exhausted, it's going to take a long time, correct?
Correct.
That's different than if a situation where you turn in the 211 years later after they've collected the taxes based on your information, which can happen that way as well. Okay, so you see the difference? So the question really that's important to know is, when did you give the tip? You follow me? Most people use the 211 to give the tip, if you follow me, right? But there are situations where people will be an informant and provide the tip information, provide their name, and then many years go by, and then they file the 211. And there's nothing wrong with that. Although there's a question of can you tie it together, right? Because if you give a tip like an anonymous tip, there's no way to tie you to the information, correct? So the 211 requires you to put your name, all your official information. You're not anonymous at that point. So what's starting to happen though is the cases where what happens if you make an application and they reject it just right off the top. And you say, well, I don't think you should have done that. Well, the problem you get into is what happens if you turn in information and they just feel it's not strong enough, it's speculative. Then they may not investigate it. And what the court's looking at is, should you be allowed to tell them that they should? And you can't. You cannot force the tax collector to go investigate and determine the merits of your information. All they can do is look and see, did your information lead to the collection of lead to an action that then led to the collection of taxes? Do you follow me? Mm-hmm. So it's very interesting because you would think that a rejection of your information, whether it's called a rejection or a denial, what you're getting into is, are we talking about one of those situations where your tip led to action, led to taxes being collected? So if you think about it, if you submit an application and it comes back quick with a denial, well, then that more than likely means they did not investigate the matter, and they have that prerogative. So therefore, you could not appeal that. You arguably should not appeal that because you have no evidence whatsoever to show that they took an action based on your tip or your information. Got it?
They don't give you a reason of the rejection or send you anything to...
Right. So let's say they say, we just think what you're claiming is speculative, right? For example, someone says, I don't know, but I just think, so-and-so didn't pay their taxes, and you have no proof. They could reject that. They would say that's speculative. What do you have as proof that they did not pay their taxes? Okay. If they deny that claim and you go to tax court or try to go to tax court, they're not going to take that case, and they do not have jurisdiction. So the key to a claim 211 situation right now under the court is that you have to show them that not only did you give, so it's three parts, Gilbert, pretty clear. You have to show them that you gave them valuable information. You have to show that they took action on that information, right? And that that information that you gave them resulted in proceeds that they collected, from which you get a 15 to 30% award. Got it? So it's all four of those parts, basically, as I lay them out. So the case that just came out, Gilbert, interesting enough, is called Berenblatt. That's BERENBLATT, v. Commissioner. It's May 24th, 2023, so hot off the press. And what we talk about there is a unique aspect of this is again one of those situations where the informant person giving the tip is talking to the IRS. Years go by, and the informant believes that they've not only acted on the information, but they've collected proceeds, files the 211 after many years going by. In other words, the 211 didn't go in on the front end of the information being provided. It went in on the back end. See what I'm saying? And the person files the form as a means by which to get proof that hey, I know you collected money. I want my cut, as a person that provided the information. So Berenblatt pulls together that situation. What happens if they then, after you say, I think you went out and got money, I believe you did act on my information, and I'm owed an award? What happens in the effort to get into that? They say, we don't have any evidence that we collected based on your information, right? How are you going to prove it? Well, in tax court, you would try and pursue what we call discovery and get at the files and so forth. Well, there's a lot of limitations on that in tax court. So Berenblatt is a case that has come out and said, okay, under 7 years had gone by, you come in and say, hey, I want to pursue this record. Well, here's the catch. In order for you to when you have administrative actions like this with the IRS whistleblower and all like this, it's dealing with what we call administrative law. The administrative record, the government's responsible for compiling a record of your file. Okay? So in this case, they come forward and say, here's the record. Here's what we did, and there's no evidence that we got any taxes based on your information. Got it? See where we are? So we're in a kind of different kind of situation where the record is presented and it doesn't show them collecting any money based on your information. Got it? All right. With all that being said, what this case comes out and says is, yes, they have jurisdiction, okay, to review this kind of situation, this look-back situation, all right? But in order for them to supplement that administrative record, in other words, allow you to do additional discovery, all right, you have to show bad faith on the part of the service, okay? So it's going to be incumbent upon you in the effort to supplement that administrative record to show bad faith by the service in not providing that administrative record. Got it? So the bottom line with this, Gilbert, is what I would say is the ability to get the court to, if you will, vindicate your situation is dependent on a number of variables, right? Okay. I see you're very concerned over there. Is everything okay?
Yeah.
All right.
I'm right there.
Okay, so at the end of the day,
well, it's a concerning situation.
Well, of course it is, and you're concerned, and I get it. And I see you twiddling with some papers and stuff. Okay, so and it's all right. It's it is a paper. Lots of papers go around with the taxes.
Well, the taxes, it's all about papers and money.
It's like, so what we try and do with this is, so our audience, to sum up, what I would say is our audience needs to know that the process of 211 and going to court based on this latest case development called Barenblatt is that it's a very high standard to prove your case in the tax court. So assuming you even clear the hurdle we talked about, which is that you believe you got evidence that they did collect taxes, you're going to have to prove it. And if it's not in their administrative record, you're going to have to fight hard to get that record to supplement. So your hope is, and I think this is where you're going, your hope that when you go to court and you force them to show the administrative record, that it's going to show what they did, show what you're entitled to, and you're good. But if it doesn't, you're going to have to show bad faith on the part of the government for not providing a complete record.
And how easy is that?
Not easy.
Of course
But
not.
So there's lots of, basically all of these taxes come up with the same kind of feeling to them. That it's on the people right around on the periphery, thinking, okay, it's taxes. But as you get into it, very complicated, very detailed, and you need someone to help work your way through it. And whether it's filing 211 or getting into court on a whistleblowing claim, you really need to have your competent counsel advising you, because you'd hate to spend a lot of time wasting your time in court. You need to know these kinds of issues up front as you try and make a good decision, correct?
And they need to hire someone like you that knows these situations to advise them and proceed with that the best way possible.
So I think for our audience, just know that brand new case out that is kind of good news, bad news. Good news is the court is saying in these look back situation there's jurisdiction, but the detail is that be careful in the process of thinking how you're going to prove your claim and what you're entitled to, because the administrative record, if it's provided by the IRS and it's suggested they have a complete record, you have to prove bad faith in them failing to compile that record. So Barenblatt is the case, stands for the proposition that you're going to have to show bad faith in the compiling of that administrative record in order to use the discovery process in the tax court to its fullest ability to prove those taxes that you claim that, or prove the amount of the reward that you claim that you're entitled to.
Absolutely, and that's a good good advice. Again, folks, if you have any questions pertaining to Form 211, or if you are in a situation similar to what Mr. T. Scott Tufts mentioned, or any other situation, call him at 877-647-7887. Again, that number is 877-647-7887, or you can email him at stufts@pcc.law. Again,